Hi, welcome to this week's lecture. We're going to talk about Hipaa today. Hipaa was enacted in the late 90s, 1999 if my memory is correct, but it was not actually put into practice until 2003. And Hipaa created a lot of agony and a lot of misery and a lot of questions about how to conduct clinical research under the umbrella of Hipaa. And so a lot of these questions in the ensuing years have been sort of addressed. And how Hipaa applies to you as a clinical research coordinator is going to be important to understand. So here we go. First of all, let's start talking about the privacy rule. The privacy rule is called the Standards for Privacy of Individually Identifiable Health Information, which no one wants to say, and that's why it sort of got shortened into the privacy rule. It is the national minimum standards for how we handle PHI. It's established by the Department of Health and Human Services, and you can find it in this location. If you really have insomnia and you really can't go to sleep, the language here might really do it for you. But we have to understand how the privacy rule applies to clinical research coordinators. So let's talk about the difference between the privacy rule, the common rule, and all of our nice FDA regulations. So I'm going to put them together in sort of this one sort of visual place so you can cross-reference and hopefully help you to distinguish the difference between them, because they all sound like Hipaa laws. So the privacy rule, what I just mentioned before, the nice long title. And then when I say HHS on this slide, I'm talking about the common rule and then also FDA regulations. So the focus of the privacy rule is really about disclosing PHI. And as a little primer, we're talking about personal health information. So if you remember back from CLST 1371, we said there's 18 PHI identifiers like name and address and medical record numbers, serial numbers off medical devices, all of those kinds of things, biometrics, so thumbprints, things like that. So the privacy rule is just really talking about what happens with someone's PHI. The common rule and all of our corresponding FDA regulations are talking about risks associated with privacy in regard to participating in clinical research. So the privacy rule applies when you go to see your doctor, but if you were participating in a clinical trial, then the common rule and the FDA regulations would apply, right? So in terms of the privacy rule, the scope then applies to a covered entity's use or disclosure of the PHI, including for any research purposes, regardless of whether the funding or the research is regulated by the FDA. With regard to the common rule and FDA regulations, then, the FDA regulations only apply to research over which the FDA has jurisdiction, and the common rule HHS regulations apply only to research that is conducted and supported by HHS or under applicable Office for Human Research Protection's approved assurance. When you're working as a clinical research coordinator, you're going to use the book that you bought for this semester. Hopefully you have the textbook. It is a wonderful reference guide, because at some point this question will come up and you'll be sitting at your desk and you'll think, I vaguely remember talking about this in the GCP class, but I can't remember the details. You're always going to have a reference to go back and look at these things. You'll also have people at your site, if it's a big site, to talk to, people at your sponsor, and the IRB to talk to as well, if you're ever confused about the different regulations. I want to talk briefly about the HITECH Act. It's the Health Information Technology for Economic and Clinical Health Act. It's fairly new, and it promotes the adoption of health information technology. So the HITECH Act is a wonderful platform, and it has created the concept is to create and roll out technology so that health information can be shared. So the idea is that it's going to create a nationwide network of electronic health records. Bexar County also already does this, and hospitals already participate. So if I'm a patient, I live in San Antonio, I get my care in San Antonio, but I fall and break my leg while I'm skiing in Denver. It would be very difficult for that emergency room physician in Denver to know all of my medical history if I'm unconscious, for example. And then even if I am conscious and I'm a good historian, it's really hard. I would not know what my lab values were and things like this. So the network of electronic health records, the idea is that it's really going to facilitate a really smooth transition of care from provider to provider. The HITECH Act does require that records must be used in a meaningful way. So in other words, the example I gave you, I live in San Antonio, but I broke my leg skiing in Denver. That meaningful way would be in terms of my care between locations. The HITECH Act, the reason I'm mentioning this, not only is it really going to be, I do believe, a wonderful world someday when we do have a nationwide network of electronic records, but it also strengthens a lot of the Hipaa requirements. And if you're interested to see how some of this stuff works, you can go to this website. It's for us locally. If you're in San Antonio, this will be interesting to you. So, who is a covered entity? I think we've talked about this in other classes, but it bears repeating because the language in the Code of Federal Regulations does talk about covered entity over and over and over again. So you're thinking, who is that? It includes healthcare plans, healthcare providers who transmit health information in electronic form, healthcare clearinghouses. Now, those are a little bit of a sort of a behind the scenes kind of thing in medical care, but these clearinghouses do billing services, they do repricing services. Community health management information systems could be considered a healthcare clearinghouse. And then health information systems. Honestly, as a clinical research coordinator, the second bullet point is where you're going to be. You're going to be a healthcare provider who transmits health information in electronic form. Even if you yourself personally never transmit health information electronically, you are doing business in an organization that does transmit electronically. So here's an example. You work for a hospital. That hospital sends claims information electronically. So in terms of the claims, they have to include PHI, therefore they qualify as a covered entity. A private practice will also do the same thing. A private practice will use limited PHI to transmit claims information to third-party insurance companies. So in that respect, if you are an employee of those organizations who are covered entities by virtue of your relationship as an employee, you are also considered to be a covered entity. So clinical research coordinators are by and large covered entities. Some things that are not covered entities would be, for example, your IRB. Your IRB might be part of the hospital or the healthcare system in which you work, but the IRB itself does not transmit health information. So let's talk a little bit about the difference between authorization and consent. An authorization allows covered entities, which is research coordinators who are employed by covered entities, to use or disclose individual PHI. So an authorization is important for research purposes. The consent document, when we've been talking about the consent form through all of these classes, is used to inform research subjects of the risks and benefits associated with participation. So the authorization allows the covered entity to use that PHI. The consent form is simply that document by which we talk about the risks and benefits of participation. Now, the privacy rule allows the inclusion of that Hipaa authorization that I just mentioned in the first bullet point to be included in the informed consent document. It is really virtually impossible to conduct clinical research without an authorization, because that PHI is necessary for conducting a trial, because we know that in order for a sponsor to say a new drug, a new investigational drug is safe and efficacious, and to make that case to the FDA requires data, and some of that could be PHI. So you could include that HIPAA authorization in the consent document, because in all honesty, if a participant does not allow the HIPAA authorization, they really can't participate in the clinical research. When you put them together, they're called a compound authorization. Either having the authorization stand as a separate standalone document and then having the consent form as its own separate document is fine. Putting them together into the compound authorization is fine. It really doesn't matter how it's done as long as you have the authorization and the consent. So you could easily put them together and have just one document for the participant. So let's talk a little bit about privacy boards. Privacy boards are put together to consider requests for waivers of consent for use and disclosure of PHI for research purposes. An IRB can make that decision. You can go to your IRB and request a waiver of consent. Some IRBs will set up their own privacy boards, and the only thing the privacy board does is then considers the request for waivers. It doesn't have any other authority. It is in and of itself not an IRB. It might be part of an IRB, but the privacy board only has one function, and that is to look at waivers of consent. So it has no other authority, but it can be part of an IRB. So to request from either the IRB or a privacy board to undertake research using PHI without consent, some criteria have to be met. One thing has to be impractical to conduct research without the waiver of consent. So you really have to make a very strong and compelling case that there's really no way around this. It has to also, you have to make a compelling case that it involves no more than minimal risk to individual privacy. And that IRB or the privacy board is going to ask very detailed questions about how you're going to ensure that it involves no more than minimal risk. It also has to include a plan to protect PHI from improper use. It has to be more than just, I promise we will not use PHI improperly, but you have to say what steps are going to be undertaken to protect the PHI. If PHI is maintained separately, it has to include a plan how the PHI will be destroyed and when, because it has to be done as soon as is reasonably feasible. So then let's talk about preparatory review. So using review to prepare for research. The law allows covered entities the ability to review PHI without authorization in order to identify potential subjects, which is really nice, because otherwise you would have to have an authorization from every individual potential subject to look at their records and to peruse their PHI. So this is really nice. This is a very thoughtful bit of law because it does allow some identifying practices to happen. Prior to this review, the researcher has to inform the organization, in other words, oftentimes it would be the IRB, the use of PHI is solely for purposes of preparing for research. And that's the only thing that's going to be done with the PHI. The PHI will not be removed from the covered entity during the review. So, your principal investigator or you cannot go and withdraw and remove PHI during the review. And that the review of the PHI is necessary for research purposes. So just like we said a minute ago, you have to make some really compelling arguments. We said before we would like to waive the authorization. In this case, in order to identify potential subjects, you have to make these assurances. The PHI is necessary and is only going to be used for preparing. PHI won't be removed, and review is necessary for research purposes. So you have to make some thoughtful assurances. So what are some preparatory research activities? Like how would you could understand that, but when would you need to do this? So Writing a protocol, if you're working with an investigator that also wants to conduct his own research, that might require writing a protocol. So you might want to look at this PHI to do that. Developing a research hypothesis might revolve around looking at PHI. Analysis of available patient population by diagnosis or other PHI criteria. So for example, your investigator is interested in a research hypothesis about teenagers with asthma. So one of these other things might involve looking through that practice or through those hospital records to say how many children aged 12 to 18 with a certain type of asthma are seen annually. So looking at the patient population for feasibility purposes. Subject recruitment, so you can look for potential subjects there. Identifying prospective research participants who would meet the eligibility criteria. So not only do you want to say, do we have enough teenagers with asthma to be able to support a study, but if that is the case, then can we also find potential participants who meet the eligibility criteria? So getting down and digging down a little bit deeper. So contacting potential participants, I just said you could find them, so can you contact them? A couple criteria here. We have four we have to think about. In the first one, if the researcher is a workforce member of a covered entity, the researcher may contact the potential study participants for the purposes of seeking an authorization. We've already said you don't need the authorization to find them, but you can contact them. This is part of this would be normal, and this would be done in terms of this is the covered entity's operations. The covered entity may contract with a business associate to assist in contacting individuals on behalf of the covered entity to obtain authorizations. So this is sort of getting at the discussion question we had this week. So the covered entity could hire a third party to assist, and that would be very reasonable. When the covered entity enters into a contract with a third party, the third party then is essentially, in essence, acting on behalf of the covered entity as if it was the business of the covered entity, and it is. Third situation, a covered health provider may discuss treatment alternatives, including trial participation with patients. So there's already an established relationship between the healthcare provider and the patient. So they can discuss treatment alternatives, including trial participation, when it is part of the patient's treatment. There's already an established relationship. This is part of the covered entity's healthcare operations. And then number 4. When an IRB has partially waived the authorization requirements to disclose PHI to a researcher for recruitment purposes, the covered entity can simply disclose the PHI necessary for the researcher to contact the individual. So here we have some references, the clinical research and privacy rule link, and then the health information privacy link there too. So I hope that sort of clarified some of the things about the discussion question this week about using a third party and whether this is okay and when it's okay. I love your questions. If any of this is unclear, or if you want to discuss this at any length, or you have more questions, I would love to hear from you. And otherwise, I will talk to you soon. Take care.